Hi everyone. I'm Claire and my partners are Sunny and Zephora, and we will be presenting on the court case of S-1 v. Turlington, 1981. So in this presentation, we'll cover facts, prior decisions, ruling, rationale, scope, significance of the case, a couple questions to consider, and our references. So the facts. This case originated in 1981 in Hendry County, Florida at Clewiston High School. The district expelled 7 of the 9 plaintiffs in the early part of the 1977-1978 school year for alleged misconduct. There were 9 plaintiffs total. Expulsion also included the 1978 and 1979 school year. And that is the maximum time permitted by law for expulsion. All of the plaintiffs were classified as educable mentally retarded, or EMR, mildly mentally retarded, or EMR/dull normal. Since S-1 was not classified as seriously emotionally disturbed, his misconduct could not be a manifestation of his handicap, and the plaintiffs' alleged violation of their rights were under the Education for All Handicapped Children Act and the Section 504 of Rehabilitation Act of 1973.
Okay, so prior decisions to this case. In the case of Goss versus Lopez of 1975, the rights of 8 students at a school in Columbus, Ohio had been violated when they were suspended due to misconduct for up to 10 days without prior notice or a hearing. The Supreme Court ruled in favor of the students, stating that in order to adhere to the procedural safeguards put into place for students and protected by the 14th Amendment, school officials must give either written or oral notice to students before a suspension of 10 days or less. The Hendry County School Superintendent determined that S-1 was not classified as a child who was emotionally disturbed, which meant that his behavior could not be linked to his handicap. And then the ruling. So it came from the Court of Appeals, 5th Circuit. The District Court for Southern District of Florida ruled in favor of the students. They ruled that the students who were expelled were denied the right to FAPE. Students could not be expelled due to behaviors that were related to their disability. And an injunction was placed to make sure plaintiffs were given their rights, which were basically their educational services and procedural rights. And then the rationale. So as far as the Education for All Handicapped Children Act went, the decision/ruling was that students had the right to appropriate education, and the plaintiffs were denied, who were expelled, were denied this right. And then Section 504 of the Rehabilitation Act of 1973, the decision impacted them because only trained and specialized groups could change educational placement, and students needed to be given necessary services and procedural regulations that were enforced.
So for the scope, this is basically who this case affected, and we included that it affects all students with disabilities, those who have physical behaviors, those with IEPs and the IEP process, and also the manifestation determination meetings becoming mandatory to ensure that students with disabilities are not being disciplined for sorry guys, for actions that are caused by their disabilities. So we'll go into the significance of the case. where before a handicapped student can be expelled, a trained and knowledgeable group of people must determine if the student's misconduct is related to the handicap. The expulsion requires the procedural protections of the EHA and Section 504. And under the EHA and Section 504, expulsion is a tool that can be used, but complete termination of educational services is not allowed. And all are entitled to due process hearings before they are kicked out or expelled. So some questions to consider are, what would have been a more appropriate way to address the actions of the plaintiffs rather than expelling them from school for more than a year? How would you teach about appropriate actions towards peers and teachers in your own classrooms? Can you think of students you have had who have personally been impacted by this case? And these are our references. Thank you guys for listening.